Aggregate settlements, from the defense point of view, are desirable, necessary. The litigation historically could not move forward without them. But we view the ethical issues of aggregate settlements from the outside, because the ethical rules that are prevalent in every single state, and they all follow Rule 1.8 of the model rules, require the plaintiff's lawyers to undertake certain obligations if they're going to have an ethical or an aggregate settlement. So aggregate settlements, I said 2,000 cases. There have been aggregate settlements of 10,000 cases, 20,000 cases. The Semino case in Texas back in about 1989 was, 3,500 individual cases that were all consolidated for trial before Judge Parker and Judge Schell. Those cases could not be resolved without an aggregate settlement. So it's something the plaintiffs desire. It's something the defendants want. It's to the advantage of the plaintiffs, because without multiple plaintiffs, the plaintiffs lose the ability of having the scale of multiple plaintiffs funding the litigation, and the defendants like aggregate settlements because it helps them resolve large numbers of cases and buy, at least temporarily, their peace. So what's the hallmark of an aggregate settlement? Allocation and conditionality. Allocation is you've got a collection of plaintiffs, you're making an offer if you're a defendant, and you're telling the plaintiff you have to allocate these funds among your collection of plaintiffs, but the condition is they either all have to accept it, or a supermajority or a majority have to accept it. That's when you see those things, you've got an aggregate settlement. It can be as few as 2 cases. You can have an aggregate settlement with two plaintiffs. And you can have different degrees of conditionality and allocation. You can have a lump sum. I'm going to pay you $2 million to settle all of your cases, and you've got 20 cases. You decide how to divide the money up. You can do it by, you can negotiate individual values against a capped amount. That's still an aggregate settlement. You can classify the plaintiffs by disease type. It's still an aggregate settlement. And then you have to have different rules for voting on it. Sometimes the defendant will say everybody has to agree, or at least a large number have to agree. And the reason for those kinds of rules is you don't want one plaintiff with a weak case to scotch a whole deal on behalf of most of the people who want to make the deal. So you have to, sometimes you say we have to have 85% of the people accept, or all the mesothelioma cases have to accept, but we'll let out some of the weak asbestosis cases, because you want to buy your piece. And you don't want to, if you're a plaintiff's lawyer, you don't want to have your weak claims hold your valuable claims hostage by trying to veto the deal. And then how do you go about getting approval of that? Because the plaintiff's lawyers who have the ethical obligation under Rule 1.8 have to deal with how they fulfill their obligations under their state bar rules of full disclosure. And sometimes they can try to deal with it in part in their retention agreements by putting certain disclosures there. Sometimes they ask for court approval. We've had aggregate settlements in California where we've hired mediators who are experienced in asbestos litigation to essentially look at the allocations and say that they thought they were fair. We did that at the request of the plaintiff's lawyer because he wanted that added level of comfort. I don't know, frankly, whether that would comply with Rule 1.8, but it's a good shot at getting that done. Here's the rule that actually applies to criminal and to civil cases. It's the same one that Chris showed. And you'll notice it says that you have to have disclosure, including the existence and nature of all claims and the participation of each person in the settlement. Those are very vague claims. Do you have to, for example, if you're a plaintiff's lawyer, disclose the names of everybody in the group that's settling, disclose the medical conditions, and disclose how much each person is getting? The rule doesn't really tell you that, and there's very little case law that interprets it, and we're going to hear from Judge Davidson in a few minutes, who actually decided one of these aggregate settlement challenges. These are a few of the rules from the larger jurisdictions. They're almost all identical. I believe all 50 states have the same rule, essentially. It's all following Rule 1.8. I think Texas has a few more requirements, but not by much. And so it's a universal problem. No matter where the litigation is going, you have this problem about getting the cases approved for settlement. The defendants want to make sure the settlements stick. We don't want to have settlements come back. And I have to say that whatever the ethical problems aggregate settlements pose for the plaintiff's lawyer, in 30 years I've never had an aggregate settlement come back and have the settlement set aside. If there's a problem with the aggregate settlement, the problem usually comes up in a lawsuit by the disgruntled plaintiff suing his lawyer. And I think that's what happened in the RC case that we're going to hear about. So this was just an example. If you have 200 cases you're trying to settle and there's 5 mesotheliomas, 20 lung cancers, 35 confirmed asbestotics with varying degrees of impairment, and 140 disputed asbestosis cases, and you're making an aggregate settlement, how do you, if you're a plaintiff's lawyer, deal with a lump sum offer and still comply with Rule 1.8? So you can just put the money on the table, $1.7 million. I know that the plaintiff's lawyers will say that's never enough. That's not for that list of cases. It should be like $20 million, right, John?
You were just using that for an example.
Yes, it's from a defense perspective. But you can classify them by disease. But then even within the disease classifications, how do you tell one mesothelioma plaintiff that he's going to get, will he get $100,000 or will one get $150 and the other one will get only $50? And how do you deal with that problem? And these are questions now that we're going to talk about for a moment that really aren't defense problems. They're I think more in the plaintiff's side of the table. But for example, under the rule to comply, do you have to tell all of your clients about all the medical conditions that all of your other clients have so that they can fairly evaluate the settlement and decide whether or not the money they're being allocated is fair? And I don't know how the plaintiff's lawyers do that, but that's a question. Do the plaintiffs who are jointly represented have an expectation of confidentiality of their medical information one from the other? In other words, in order to evaluate whether the settlement I'm getting as a plaintiff in a group, am I entitled to know the medical information about my co-plaintiffs? And there's an argument that under 1.8, the jointly represented plaintiffs have no expectation of privacy among themselves. And they can compel the disclosure of their co-plaintiffs' medical reports and documents in order to evaluate the fairness of the settlement. I don't know how the plaintiffs' lawyers deal with that, but I think you have to at least confront that. Can the plaintiffs waive in the retention agreement the right to veto an aggregate settlement? There's at least some case law that suggests you cannot, despite the law of contracts, waive your right to evaluate a settlement in advance. Can you make the allocation without the informed consent of the plaintiff, even when you get some judge to approve it? I would think you probably could not under the rules. It would help, but I'm not sure it would be sufficient to prevent a lawsuit from one of your disgruntled clients. The penalty for violating the rule. I've not seen any penalties levied against any defendant for making an offer, although Judge Davidson tells me there's some theory floating around about conspiracy.
I'll talk about it.
Okay. The penalty seems to be lawsuits by the disgruntled clients against their lawyers claiming that they would have gotten a better deal had there been no settlement, or a lawsuit for breach of fiduciary duty to recover the attorney's fees that were paid. I suppose theoretically the plaintiff could bring a claim to set aside the settlement in its entirety, or at least as to that particular plaintiff. I've not seen that happen. So that's how we view it from the defense side, aggregate settlements. They're necessary, they're important, they're quite useful. Even, for example, if you have two cases where the plaintiffs and the defense lawyer know generally what the value of the cases combined is, but you have a disagreement about how much case A is worth versus case B, it's not unusual for the defendant to say, I'm going to pay you $500,000 for these two cases, but I think I evaluate case A as being worth 100 and the other one's worth 400, and the plaintiff's lawyer says to himself, I think the cases are worth 250 each, and you can't agree on a value. you settle them as a unit, and then the plaintiff's lawyer gets to allocate the money between the two cases, or maybe it's 4 cases or 6 cases. It's a useful way for the defendants and the plaintiffs to get together to resolve the cases if they can't agree on every single case. So it's something that comes up all the time, even in small groups of cases, and you have to do it. Otherwise, the litigation doesn't get settled.